There is a disturbing memorandum circulating through the back channels of the Department of Justice right now, and the numbers within it are staggering. Leaked internal documents suggest the U.S. government is targeting a 16,000% increase in denaturalization referrals for 2026. This isn't just a policy tweak, it is a declaration of intent to fundamentally alter the permanence of American citizenship for naturalized immigrants. If you swore the oath, pledged allegiance, and thought your journey was over, this news is a cold awakening. But before you panic, you need to understand the mechanism behind these numbers. The reality is far more complex than the headlines suggest, and the legal hurdles standing between the government and your passport are immense. Welcome to Immigration News Desk, where we dissect the operational realities of the immigration system that rarely make the evening news. I am here today to break down the denaturalization quota scandal. We are going to cut through the fear-mongering and look at the hard legal facts, what the guidance actually says, the massive bottleneck at the Department of Justice that protects you, and the specific types of cases that are truly in the crosshairs. If you value expert analysis over hysteria, hit that subscribe button right now. And if you know a naturalized citizen who is losing sleep over this, share this video with them immediately. It is the reality check they desperately need. To understand the gravity of this shift, we have to look at the historical context of denaturalization in the United States. For the vast majority of the last century, stripping someone of their citizenship was a rare, extraordinary, and somber event. It was reserved for the absolute worst of the worst, the monsters of history. We are talking about Nazi war criminals who hid in Ohio suburbs, commanders from the Balkan genocides who lied on their refugee applications, or high-ranking terrorists who infiltrated the system. It was not a tool used against the average immigrant. Between 1990 and 2017, the United States averaged approximately 11 denaturalization cases per year. Think about that number. 11. In a country of millions of naturalized citizens, the government only pursued revocation a dozen times a year. It was a statistical anomaly, a lightning strike. Even when the Trump administration launched Operation Janus to identify fingerprint fraud, the numbers only rose slightly. Now, compare that to the leaked guidance reported by the New York Times and Newsweek. The documents instruct USCIS field offices to refer between 100 and 200 cases per month to the Department of Justice. Do the math. That is a potential jump to 2,400 cases a year. That is where the 16,000% increase figure comes from. It represents a fundamental shift in enforcement philosophy. The government is attempting to move from a reactive model, where they only pursued cases that fell into their lap due to massive scandals, to a proactive model, where they are actively mining old data to find discrepancies. They are using digitized records, biometric fingerprint matching, and interagency data sharing to look for lies told 10, 20, or 30 years ago. They are auditing the entire naturalized population looking for cracks in the foundation of your status. This is an audit of the past, applied to the present. However, a referral is not a revocation. And this is the most critical legal nuance you must understand today. Denaturalization is not an administrative process. An immigration officer at USCIS cannot just cancel your citizenship like they cancel a tourist visa. They cannot sign a form at their desk and issue a deportation order. They have absolutely no power to strip you of your rights on their own. Denaturalization must happen in a federal district court. This is the legal firewall that protects you. To take away your passport, the Department of Justice must file a formal lawsuit against you, either a civil complaint or a criminal indictment. They must drag you into a federal courtroom, and they must prove their case before a federal judge who is appointed for life and is independent of the immigration agency. The burden of proof in these cases is extraordinarily high. It is one of the highest burdens in American law. The Supreme Court, in the landmark case Schneiderman v. United States, ruled that citizenship is a priceless asset. Therefore, the government must prove their case by clear, unequivocal, and convincing evidence. This is much higher than the preponderance of the evidence standard used in normal civil lawsuits. It means the evidence must not just be more likely than not, it must be overwhelming. It must leave no serious doubt in the judge's mind. Specifically, the government must prove that your citizenship was either illegally procured or obtained by concealment of a material fact or by willful misrepresentation. I want you to focus on that word, material. This is the legal shield that protects thousands of people. What is a material fact? The Supreme Court has clarified this in Cungus v. United States. A lie is only material if telling the truth would have resulted in the denial of your citizenship. If you got your address wrong on a form 20 years ago, that is an error, but it is likely not material. If you had told the truth about your address, you still would have become a citizen. Therefore, they cannot denaturalize you for it. If you forgot to list a speeding ticket, that is not material. However, if you lied about a murder conviction, or being a member of a terrorist organization, or being married to two people at once, that is material. If the truth had been known, you would have been denied. The courts have consistently ruled that minor errors, innocent mistakes, and memory lapses are not grounds for the capital punishment of citizenship stripping. Now let's look at the logistics. This brings us to the DOJ bottleneck. The entity responsible for filing these lawsuits is the Office of Immigration Litigation, OIL, at the Department of Justice. Having analyzed federal litigation teams for years, I can tell you, they are already underwater. They are currently defending the government in thousands of appeals, asylum cases, mandamus lawsuits for delayed visas, and habeas corpus petitions. They are stretched thin. Litigating a single denaturalization case is a war. It is not a 15-minute hearing. It involves discovery, where lawyers demand millions of pages of documents. It involves depositions, where witnesses are questioned under oath for days. It involves pre-trial motions and potentially weeks of trial time. A single case can cost the government hundreds of thousands of dollars and take 3 to 5 years to resolve. So, here is the operational reality. What happens when USCIS sends 200 referrals a month to an office that has the manpower to handle maybe 20? Triage. The DOJ attorneys are not robots. They are lawyers who hate losing. They will look at the pile of referrals and they will cherry-pick the absolute strongest cases, the slam dunks. They will go after the violent criminals, the sexual predators, and the massive fraudsters. The cases involving technicalities, the cases involving a forgotten job on a resume from 1995, the cases involving a minor tax error, those files will likely sit in a cabinet, gathering dust, until the statute of limitations on related crimes runs out, or the administration changes. The quota is an administrative target for USCIS officers to look busy, but it cannot force the DOJ to litigate unwinnable or low-value cases. This bureaucratic friction is your safety net. The machine is simply not big enough to process the volume of victims the memo calls for. However, we cannot ignore the danger of the quota itself. While the DOJ might not prosecute every case, the investigation phase can ruin your life. When you give field officers a target number, find me 100 fraudsters this month, you incentivize them to find problems where none exist. You encourage phishing expeditions. An ambitious officer might look at your file and strain to find a discrepancy just to meet their monthly metric. They might see that you claim to be single on a tax return, but married on an immigration form. They refer you to DOJ. The DOJ might eventually decline the case, but in the meantime, you receive a notice of intent to rescind, if it's within 5 years of naturalization, or a scary letter from the U.S. Attorney's Office asking for an interview. This is where the psychological warfare happens. They call you in for an interview. They don't tell you it's a denaturalization probe. They ask you the same questions you answered 20 years ago, hoping you slip up, hoping you contradict yourself. They are trying to manufacture the willful misrepresentation evidence they need. The stress of this, the legal fees, the sleepless nights, the fear that your life is unraveling, is the punishment, even if they never file the lawsuit. This is why the quota system is so dangerous. It weaponizes the bureaucracy against innocent people to generate statistics. Let's dissect the specific types of cases that are actually at risk. The government has limited resources, so they target specific profiles. If you fall into one of these buckets, your risk is real. If you don't, your risk is statistical noise. The first profile is the double life cases. This is the primary target of the digital fingerprint initiatives. These are individuals who came to the U.S., got ordered deported, left, changed their name, and came back with a fake identity to get a green card and citizenship. For decades, they got away with it because paper files didn't link the two names. Now digital fingerprints link the two identities instantly. If you have two A files under different names, you are in the danger zone. The second profile is the persecutor cases. These are people who lied about their involvement in human rights abuses abroad to get refugee status. We have seen cases of Bosnian prison guards or South American paramilitary members who lied to get asylum. The Human Rights Violators and War Crimes Center, HRVWCC, specifically hunts these people. The third profile involves sexual offenders. This is a high political priority. Individuals who committed sex crimes against minors before naturalizing but concealed them, or committed them during the statutory period of good moral character, usually the 3 to 5 years before citizenship. Even if the crime happened years ago, lying about it on the N400 makes the citizenship fraudulent. The fourth profile is complex marriage fraud rings. We are not talking about a couple that got divorced too quickly. We are talking about organized rings where one U.S. citizen was paid to marry 10 different people to get them green cards. Or cases where the immigrant was still legally married to a spouse in their home country while marrying a U.S. citizen here. Bigamy. This nullifies the underlying green card, which poisons the fruit of the citizenship. If your skeleton in the closet is that you worked unauthorized on a student visa 20 years ago at a pizza shop and didn't mention it, or you got a speeding ticket you forgot to list, you are statistically safe. The resources required to denaturalize you over that exceed the value to the government. They are hunting whales, not minnows. A federal judge would likely laugh a case out of court if the government tried to deport a grandmother over an unauthorized job in 1990. We also need to address the statute of limitations. There is a common misconception that after 5 or 10 years, you are safe. That is false. There is no statute of limitations for civil denaturalization. They can come after you 40 years later. We have seen cases of 90-year-olds being denaturalized for lies told during Y2. However, the older the case, the harder it is to prove. Witnesses die. Documents are lost in floods or fires. Memories fade. The government has the burden of proof. If they claim you lied in 1995, but the transcript of the interview is lost, they cannot prove what you said. A federal judge is going to be very skeptical of a government attorney trying to strip citizenship based on a shaky, incomplete record from the Reagan era. While the legal defense of laches, unreasonable delay, is hard to use against the government, the practical reality of prosecuting old cases acts as a de facto limitation. They generally focus on cases from the last 10-15 years where the evidence is digital and fresh. So, what is the actionable advice for you watching this video? How do you sleep at night? First, if you are already a citizen, live your life. Do not stop voting. Do not stop traveling unless you have a specific, known warrant or fear. Do not self-deport out of fear. The odds of you being targeted are statistically 0 unless you fall into those high-priority criminal categories I mentioned. The fear is the weapon. Don't let it work. Second, if you are applying for naturalization now, this is where you must be vigilant. The best defense against denaturalization is a bulletproof naturalization application today. Be scrupulously honest. If you have a criminal record, disclose it, even if it was expunged. If you owe taxes, fix it before you apply. If you have been married multiple times, document every divorce decree perfectly. Do not give them a hook to pull later. Consult with a lawyer if there is anything ambiguous in your history. It is better to be denied naturalization now and stay a green card holder than to be granted it and stripped of it later for fraud. Third, the lawyer up rule. If you receive any letter from the DOJ, USCIS, or the U.S. Attorney's Office mentioning revocation, rescission, or investigation of your citizenship, do not talk to them alone. Do not try to explain it away thinking you can charm them. You are the target of a federal investigation. Lawyer up immediately. You need a federal litigator, not just a forms attorney. These are high-stakes legal battles, and you have rights. You have the right to remain silent. You have the right to see the evidence against you. Fourth, safeguard your history. Keep your original naturalization certificate in a fireproof safe. But more importantly, keep copies of your N-400 application and all the supporting evidence you submitted. Keep your tax returns. Keep your old passports. If the government claims you lied about something 20 years from now, and they have lost the part of the file that proves your innocence, your own copy of the file might be the only thing that saves you. We call this defensive record keeping. The psychological impact of this news is intentional. It is designed to make citizenship feel conditional, to make you feel like a guest in your own country. But under the Constitution, you are not a guest. The Supreme Court ruled in Afroyim versus Rusk that citizenship is a constitutional right, not a legislative privilege. It is incredibly hard to take away. The system has checks and balances. The 16,000% number is a bureaucratic target, a wish list, not a destiny. At Immigration News Desk, we monitor the federal court dockets. We track how many of these cases are actually being filed versus how many are just threats in a memo. Right now, the wave hasn't hit the courts. It is a memo, not a movement. If this deep dive analysis helped you lower your blood pressure and understand the real risks versus the hype, hit that like button. It helps us fight the algorithm that promotes panic. Share this with your community, your church, your family, your colleagues. Knowledge is the ultimate shield against uncertainty. Stay vigilant, stay documented, and remember, you are an American and you have rights. We will see you in the next briefing.